Part 4. Placement by the Administration. Rule 1. Recruitment and placement through the Administration. Section 127. Hiring through the Administration. The Administration shall recruit and place overseas Filipino workers primarily on government-to-government arrangements, and shall therefore service the hiring of foreign governments and their instrumentalities. The Administration shall deploy only to countries, where the Philippines has concluded bilateral labor agreements or arrangements. As far as practicable, the Administration shall recruit and place overseas Filipino workers primarily on a government-to-government arrangement, or to labor markets not being serviced by the private sector. In pursuance thereof, the Administration shall, among others, a. Administer programs and projects that may support the employment development objectives of the Administration. b. Set parameters in servicing other foreign clients. And c. Undertake, in coordination with POEA regional centers and extension units, as well as DOLE regional offices and concerned local government units, organized recruitment activities in the provinces, in aid of the employment dispersal efforts of the government. Section 128. Recruitment and placement of overseas Filipino workers. All employers hiring through the Administration shall undertake the recruitment and placement of overseas Filipino workers, through the facilities of the Administration. The activities shall include, but not be limited to, interview and selection, referral for medical examination, processing of contracts, assistance in securing passports and appropriate visas, pre-employment orientation, pre-flight briefing, and travel arrangements. Section 129. Fees and costs chargeable to principal or employer. Unless otherwise provided by law, regulations, or bilateral agreement or arrangement, the principal or employer shall be responsible for the payment of the following. 1. Visa and/or work permit fee. 2. Airfare. 3. POEA processing fee. And 4. OA membership contribution. Section 130. Fees or costs chargeable to the overseas Filipino workers. Unless otherwise provided by law, regulations, or bilateral agreement or arrangement, the overseas Filipino worker shall pay for the following documentation costs. 1. Passport. 2. NBI or police or barangay clearance. 3. Authentication or notarization. 4. Birth certificate. 5. School credentials. 6. Trade test or assessment, if necessary. 7. Medical or health examination. And 8. Inoculation, when required by host country. Section 131. Foreign Employers Guarantee Fund. For overseas Filipino workers recruited through a government-to-government arrangement, the Administration shall, through relevant guidelines, establish and administer a Foreign Employers Guarantee Fund or FEGF, which shall be answerable for the overseas Filipino workers' monetary claims arising from breach of contractual obligations. The same must be included in bilateral agreements on government-to-government hiring. Section 132. Fees and contributions. All employers hiring through the Administration shall pay to the Administration a service fee, inclusive of the OA contribution, payable prior to the issuance of the OEC of the overseas Filipino worker. Such payment shall not be levied on the selected applicant by the employer. Prior to the worker's departure, the employer shall be required to contribute to the FEGF, to cover the worker's monetary claims arising from breach of contractual obligations of the employer, including attendant repatriation expenses. Over and above the contribution to the FEGF, and in case of termination of overseas employment without just, valid or authorized cause as defined by law or contract, the employer shall pay the worker his or her salaries for the unexpired portion of the employment contract. Section 133. Parameters for government-to-government hiring. The administration shall recruit and place workers for foreign employers under the following parameters and criteria. A. As may be requested and specified by the foreign government employer. B. As a ready goodwill vehicle for prospective employers, endorsed by diplomatic missions, or as a result of high-level meetings. And C. For new or novel markets, or alternative manpower mobilization arrangements on a pilot, or experimental basis, or for hiring projects triggered by certain recruitment violations and exploitative practices of licensed recruitment agencies. Part 5. Employment Standards. Rule 1. Formulation of Employment Standards. Section 134. Employment Standards. The administration shall secure the best possible terms and conditions of employment for overseas Filipino workers. As such, it shall develop and continually review employment standards in accordance with policy thrusts and market developments. Section 135. Minimum provisions of employment contracts. Consistent with welfare promotion thrust of the administration, the following shall be the minimum provisions in employment contracts for overseas Filipino workers. A. Complete name and address of the employer or company. B. Position and job site of the overseas Filipino worker. C. Basic monthly salary, including benefits and allowances and mode of payment. The salary shall not be lower than the prescribed minimum wage in the host country, or prevailing minimum wage in the national capital region of the Philippines, whichever is higher. D. Food and accommodation, or the monetary equivalent, which shall be commensurate to the cost of living in the host country, or offsetting benefits. E. Commencement and duration of contract. F. Free transportation from and back to the point of hire, or offsetting benefits, and free inland transportation at the job site or offsetting benefits. G. Regular work hours and day off. H. Overtime pay for services rendered beyond the regular working hours, rest days and holidays. I. Vacation leave and sick leave for every year of service. J. Free emergency medical and dental treatment. K. Just or valid or authorized causes for termination of the contract or of the services of the workers, taking into consideration the customs, traditions, norms, mores, practices, company policies and the labor laws and social legislations of the host country. L. Settlement of disputes. M. Repatriation of worker in case of imminent danger due to war, calamity, and other analogous circumstances, at the expense of employer. And N. In case of worker's death, or repatriation of overseas Filipino workers' human remains and personal belongings, at the expense of the employer. The administration may formulate country, or skill-specific policies and guidelines based on the following. A. Existing labor and social laws of the host country. B. Relevant bilateral and multilateral agreements or arrangements with the host country. And C. Prevailing conditions or realities in the market. Section 136. Freedom to stipulate. Parties to overseas employment contracts are allowed to stipulate other terms and conditions and other benefits. These benefits should be over and above the minimum requirements. Said benefits shall not be contrary to law, public policy and morals. Section 137. Disclosure of terms and conditions of employment. The licensed recruitment agency shall, prior to the signing of the employment contract, inform the overseas Filipino workers of their rights and obligations, and disclose the full terms and conditions of employment. The licensed recruitment agency shall likewise ensure that the overseas Filipino worker is provided with a copy of the POEA approved contract, to give the overseas Filipino worker ample opportunity to examine the same. Part 6. Recruitment violations and disciplinary action cases. Rule 1. Jurisdiction. Section 138. Jurisdiction. The administration shall exercise original and exclusive jurisdiction to hear and decide all cases which are administrative in character, involving or arising out of violations of recruitment rules and regulations, including refund of fees collected from overseas Filipino workers, and any violation of the conditions for the issuance of the license to recruit overseas Filipino workers. The administration shall likewise exercise original and exclusive jurisdiction to hear and decide disciplinary action cases against overseas Filipino workers, and principals or employers that are administrative in character, excluding money claims. Rule 2. Conciliation of complaints. Section 139. Mandatory conciliation of complaints. Before docketing, the administration or the POLO shall mandatorily conciliate any complaint involving an overseas Filipino worker, licensed recruitment agency, or principal or employer relating to overseas employment. In case of money claims, the same will also be conciliated in accordance with the single entry approach or SINA. The failure to arrive with a settlement shall cause the endorsement of the complaint to the appropriate office. In cases falling under Section 143G and H, herein, the settlement shall be for the return of the full amount excessively or illegally collected. However, the following cases are not subject to SINA. A. Cases referred by the POLO or any other government agency. B. Cases initiated by the administration. And C. Cases involving acts of misrepresentation for the purpose of securing a license. Section 140. Conciliation proceedings. Within 5 days upon receipt of the complaint, the administration shall notify the respondent, and schedule a conference between the parties to discuss the possibility of arriving at an amicable settlement. Where an amicable settlement is reached, the administration shall approve the same, and the settlement shall be final and binding upon the parties. Where efforts for amicable settlement fail, the conciliation proceedings shall be terminated, and the complaint shall be referred to the appropriate office immediately. Section 141. Administrative sanction. Unjustified failure by the licensed recruitment agencies, principal or employer, or an overseas Filipino worker to abide by the terms of the approved settlement, shall warrant suspension from participation in the overseas employment program, until compliance with or satisfaction of the approved settlement. In case of failure of any party to comply with terms of the approved settlement, despite the lapse of 30 days from date of imposition of suspension from participation in the overseas employment program, the administration shall, upon motion of the aggrieved party, or on its own initiative, issue a writ of execution for the enforcement of the settlement award. Section 142. Confidentiality of the conciliation proceeding. The proceeding for conciliation is confidential in nature. No evidence or testimony introduced therein shall be admissible as evidence in any other proceedings. Rule 3. Recruitment violation cases, classification of offenses and schedule of penalties. Section 143. Grounds for imposition of administrative sanctions against a licensed recruitment agency. Commission by a licensed recruitment agency of any of the offenses below, shall be a ground for the imposition of the corresponding penalty. 1. Serious offenses are those that, by their nature and effect, are punishable by cancellation of license. A. Knowingly deploying a minor. The penalty is cancellation of license. B. Engaging in acts of gross misrepresentation, for the purpose of securing a license or renewal thereof, such as violation of the anti-dummy law, or giving false information or fictitious documents, in relation to a matter that is material for the approval of the license application or renewal. The penalty is cancellation of license. C. Engaging in an act of reprocessing, by documenting workers through a job order that pertains to 1. Non-existent work. 2. Positions different from the actual overseas work, or for positions different from the actual visa category, unless covered by an undertaking of visa usage by the licensed recruitment agency and an affidavit of awareness and consent by the worker, and a job description signed by the worker and approved by the administration. Or 3. A different principal or employer whether or not accredited with the POEA. The penalty for this is cancellation of license. D. Engaging in the recruitment or placement of workers, in jobs declared by the administration as harmful to public health or morality, or to the dignity of the Republic of the Philippines. The penalty is cancellation of license. E. Transfer or change of ownership or control of a single proprietorship license to engage in overseas employment. The penalty for this is cancellation of license. F. For the sole proprietor, partner, or officer or officers or members of the board of any licensed recruitment agency, to become an officer or member of the board of any corporation or partnership engaged directly or indirectly in the management of a travel agency. Penalty is cancellation of license. G. Charging and collecting of placement fee for deployment to countries where the prevailing system, either by law, policy or practice does not allow the charging and collection of placement and recruitment fees as determined by the administration. The penalty is cancellation of license, and refund of the placement and recruitment fee collected from the worker, with interest at 6% per annum from collection. H. Charging and accepting directly or indirectly any amount greater than that specified in the schedule of allowable placement fees, or when such charging or collection is prohibited by any law, rules or policy, or making a worker pay or acknowledge any amount greater than that actually received by him or her as loan or advance. The penalty is cancellation of license plus refund of the excess placement fee collected from the worker, with interest at 6% per annum from collection. I. Passing on to the worker, fees and costs chargeable to the principal or employer. Penalty is cancellation of license plus refund of the fees and costs collected from the worker, with interest at 6% per annum from collection. J. Deploying workers whose employment and travel documents were not processed by the administration. The penalty is cancellation of license. K. Allowing a non-Filipino citizen to head or manage, directly or indirectly, a licensed recruitment agency. For this purpose. Heading or managing. A licensed recruitment agency shall refer to 1. Controlling and supervising the operations of the licensed recruitment agency or any branch thereof. Or 2. Exercising the authority to hire or fire employees, and to lay down and execute management policies of the licensed recruitment agency or branch thereof. The penalty is cancellation of license. 2. Less serious offenses are those that by their nature and effect are punishable by the penalty of suspension to cancellation of license. L. Knowingly deploying a worker below the minimum age requirement. The penalty on first offense is suspension of license for 2 to 6 months. Second offense. Suspension of license for 6 months and 1 day, to 1 year. Third offense. Suspension of license for 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. M. Charging, imposing and accepting directly or indirectly, any amount of money, goods or services, or any fee or bond for any purpose whatsoever, before employment is obtained for an applicant worker. The penalty on first offense is suspension of license for 2 months to 6 months. Second offense. suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day to 2 years. Fourth offense, the penalty is cancellation of license. The penalty shall carry the accessory penalty of refund of the fee collected from the worker, in case of non-deployment, with interest at 6% per annum. N. Collecting any fee from a worker, without issuing the official receipt clearly showing the amount paid, and the purpose for which payment was made. On first offense, the penalty is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. O. Engaging in any other acts of misrepresentation in connection with recruitment and placement of workers, such as furnishing or publishing any false notice, information or document in relation to recruitment or employment. The penalty on first offense is suspension of license from 2 months to 6 months. Second offense, the penalty is suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. P. Obstructing inspection by the Secretary, the Administrator or their duly authorized representatives. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year to 2 years. On fourth offense, the penalty is cancellation of license. Q. Substituting or altering, to the prejudice of the worker, a POEA approved employment contract, from the time of actual signing thereof by the parties up to and including the period of the expiration of the same, without the approval of the POLO or POEA. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. R. Withholding or denying release of travel or other pertinent documents from a worker despite demand. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year to 2 years. Fourth offense, the penalty is cancellation of license, plus return of the documents, or refund of the cost of the documents that the licensed recruitment agency failed to return. S. Engaging in recruitment activities in places other than that specified in the license or branch authority without a special recruitment authority. The penalty for first offense, is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. T. Appointing or designating, representatives or employees, without notice to the administration, in accordance with Section 27 of these rules. The penalty for first offense, is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. U. Allowing an accredited principal or employer, or its representative, to conduct or participate in recruitment activities outside the registered business address of the licensed recruitment agency, without prior approval from the administration. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. V. Allowing persons, who are disqualified to participate in the overseas employment program under existing laws, rules and regulations to participate in the ownership, management and operation of the recruitment agency. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. W. Failure to reimburse expenses incurred by the worker, in connection with his or her documentation and processing for purposes of deployment, where deployment does not take place without any fault on the part of the worker. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. The penalty shall carry the accessory penalty of immediate refund of expenses incurred by the worker. X. Failure to comply with any of the undertakings submitted to the administration in relation to Section 4, F. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. Y. Imposing a compulsory and exclusive arrangement, whereby an OFW is required to undergo health examinations, training, seminar, instruction or schooling of any kind, only from specifically designated institutions, entities, or persons or medical clinics, as the case may be, unless the cost is shouldered by the principal or licensed recruitment agency. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. Z. Imposing a compulsory and exclusive arrangement, whereby an OFW is required to avail of a loan from a specifically designated institution, entity, or person. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. AA. Refusing to condone or renegotiate a loan incurred by an OFW, after the latter's employment contract has been prematurely terminated, through no fault of his or her own. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. B. Facilitating, arranging, or granting of a loan to an OFW, with interest exceeding 8% per annum, which will be used for payment of legal and allowable placement fees, and making the OFW issue, either personally or through a guarantor or accommodation party, postdated checks in relation to the said loan. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense. Suspension of license from 6 months and 1 day, to 1 year. Third offense. Suspension of license from 1 year and 1 day, to 2 years. Fourth offense. The penalty is cancellation of license. C. Failure to monitor and report significant incidents, regarding the condition and status of the deployed worker in relation to Section 209. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. D. Collecting any amount as payment for documentation costs, not prescribed by these rules or other issuances of the administration, or an amount greater than the actual documentation costs, as covered by official receipts issued by entities which receive the payments. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. The penalty shall carry the accessory penalty of immediate refund of the excess amount of documentation costs collected. E. Falsifying or altering employment or travel documents of applicant worker. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. F. Inducing a worker already pre-qualified or contracted, whether deployed or not, to withdraw from, or to abandon his or her employment in order to offer him or her another, unless the transfer is designed to liberate a worker from oppressive terms and conditions of employment. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. G. Willful disobedience of lawful orders, notices, or other legal processes issued by the administration. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. H. Failure to submit reports as required under the rules and other issuances of the administration. The penalty for first offense is suspension of license from 2 months to 6 months. Second offense, suspension of license from 6 months and 1 day, to 1 year. Third offense, suspension of license from 1 year and 1 day, to 2 years. Fourth offense, the penalty is cancellation of license. 3. Light offenses are those that by their nature and effect, are punishable by the penalty of reprimand to suspension of license. I. Influencing any person or entity, not to employ any worker who has not applied for employment through his or her agency, or influencing any person or entity, not to employ any worker who has formed, joined or supported, or has contacted or is supported by any union or workers' organization. The penalty for first offense is reprimand. For second offense, the penalty is fine of 20,000 pesos. For third offense, suspension of license from 1 month to 3 months. Fourth offense onwards, the penalty is suspension of license from 3 months to 6 months. J. Failure to actually deploy a contracted worker within 60 days from the issuance of OEC without valid reason. The penalty for first offense is reprimand. For second offense, the penalty is fine of 20,000 pesos. For third offense, suspension of license from 1 month to 3 months. Fourth offense onwards, the penalty is suspension of license from 3 months to 6 months. K. Violations of other pertinent provisions of the Labor Code and other relevant laws, rules and regulations, guidelines and other issuances on recruitment and placement of workers for overseas employment and the protection of their welfare. The penalty for first offense is reprimand. For second offense, the penalty is fine of 20,000 pesos. For third offense, suspension of license from 1 month to 3 months. Fourth offense onwards, the penalty is suspension of license from 3 months to 6 months. Rule 4. Disciplinary actions against principals or employers. Section 144. Grounds for disciplinary action against principals or employers and penalties. Commission by a principal or employer of any of the offenses below, shall be a ground for disciplinary action for which the corresponding penalty shall be imposed. 1. The following are serious offenses, with their corresponding penalties. A. Unauthorized or unjustified collection of fee, or illegal exaction from an overseas Filipino worker, through whatever means, including salary deduction. The penalty for this is permanent disqualification and delisting from the roster of accredited principals or employers. B. Passing on to the worker, or deducting from the overseas Filipino worker's salary, the payment of the cost of the premiums, as provided under the compulsory workers' insurance coverage. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. C. Gross negligence leading to serious injury or illness, or disability or death of the overseas Filipino worker. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. D. Grave misconduct against the overseas Filipino worker. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. E. Conviction of an offense against the overseas Filipino worker. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. F. Compelling an overseas Filipino worker to work for another principal or employer or in another job site or worksite, or perform work different from what is provided in the contract. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. G. Unreasonable or unjustifiable delay and refusal in securing an exit visa for an overseas Filipino worker, who needs to be repatriated. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. H. Non-payment or underpayment of wages and benefits. The penalty for this is permanent disqualification and delisting from the roster of accredited principals or employers. I. Substitution or alteration of the POEA approved contract to the prejudice of the overseas Filipino worker. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. J. Violation of the anti-human trafficking law. The penalty is permanent disqualification and delisting from the roster of accredited principals or employers. 2. The following are less serious offenses with their corresponding penalties. K. Default on other contractual obligations to the overseas Filipino worker. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. L. Withholding or denying of the worker's travel and other pertinent documents. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. M. Non-acceptance of the results of valid health examinations, conducted by a DOH accredited or DOH operated clinic. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. N. Failure to monitor and report the status, condition, or significant events relating to its hired worker. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. O. Negligence leading to injury or illness of the worker. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. P. Simple misconduct against the worker. The penalty for first offense is suspension from participation in the overseas employment program from 6 months to 1 year. And for second offense, the penalty is permanent disqualification and delisting from the roster of accredited principals or employers. Rule 5. Disciplinary action against overseas Filipino workers. Section 145. Grounds for disciplinary action and their penalties. Commission by an overseas Filipino worker of any of the offenses enumerated below, shall be a ground for disciplinary action, for which the corresponding penalties shall be imposed. 1. Serious offenses. A. Pre-employment offenses. A. Submitting, furnishing, or using false information or documents, or any form of misrepresentation for the purpose of job application or employment. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. B. Unjustified refusal to continue his or her application after signing an employment contract, or to depart for the worksite after all employment and travel documents have been duly approved by the appropriate government agencies. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. B. Offenses during employment. A. Commission of a felony, or crime punishable by the laws of the Philippines or by the host country, committed during employment. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. B. Assaulting a fellow worker, the principal or employer or any member of his or her family, or any of the directors, officers, managerial or supervisorial staff of the principal or employer. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. C. Grave abuse of authority by an officer exercising supervision over other employees. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. D. Possession or use of prohibited drugs, contraband, alcohol or pornographic materials in violation of company policy or laws of the host country. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. E. Unjustified refusal to be repatriated, in case of mandatory repatriation in accordance with the declaration of the Philippine government. For first offense, the penalty is suspension from participation in the overseas employment program, from 6 months to 1 year. For second offense, the penalty is suspension from participation in the overseas employment program from 1 year and 1 day, to 2 years. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. 2. Less serious offenses. F. Unjustified breach of employment contract. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. G. Embezzlement of company funds or monies, and/or properties of a fellow worker, entrusted for delivery to kin or relatives in the Philippines. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. H. Violation of the religious and cultural practices of the host country. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. I. Violation of company policies and regulations. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. J. Insubordination or refusal to obey a lawful order of the employer or the duly authorized representative. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. K. Failure to refund the cost of his or her repatriation advanced by the principal or recruitment agency, where termination of employment was due to his or her own fault as determined by final judgment. For first offense, the penalty is suspension from participation in the overseas employment program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the overseas employment program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the overseas employment program. L. Violation of the Code of Discipline for overseas Filipino workers. For first offense, the penalty is suspension from participation in the Overseas Employment Program, from 2 months to 6 months. For second offense, the penalty is suspension from participation in the Overseas Employment Program, from 6 months and 1 day, to 1 year. For third offense, the penalty is permanent disqualification from participation in the Overseas Employment Program. Rule 4. Filing of complaints, and venue of action. Section 146. Who may file? An aggrieved person may file a complaint in writing and under oath for violation of laws, rules and regulations or other issuances relating to overseas employment. For this purpose, an aggrieved person is one who is prejudiced by the commission of a violation as enumerated in the immediately preceding rules. The administration may, on its own initiative, conduct proceedings based on reports of violation of these rules and other issuances on overseas employment, subject to preliminary evaluation. The report should state clearly the facts constituting the offense, attaching all available evidence relative thereto. The report shall be investigated by the Adjudication Office or the POEA Regional Center or Extension Units. Section 147. On-site complaints for violation of the POEA rules and regulations. The procedures under Department Order No. 8708, and/or Manual of Operations of the POLO, shall be observed for on-site complaints on violation or violations of the POEA rules and regulations. The complaint shall be in affidavit form, and subscribed and sworn before a consular official of the Philippine Embassy. It shall be accompanied by available supporting documents, and a certification of non-form shopping, and certificate of failure to conciliate. The verified complaint shall be filed with a POLO that has jurisdiction over the worksite of the complainant. The POLO shall endorse to the administration the complaint filed on site, together with the available supporting documents, for investigation. Section 148. Contents of the complaint. All complaints must contain the following. A. The complete name and complete address of the complainant. B. The complete name and complete address of the respondent. C. Specific complaint referred to in the classification of offenses. D. The substance, cause or grounds of the complaint. E. When and where the action complained of happened. F. The amount of claim, if any, and G. The relief or reliefs sought. The complaint shall be under oath, and must be accompanied by the following. A. Supporting documents. B. Certificate of failure to conciliate. And C. Certificate of non-forum shopping. Section 149. Docket and assignment of cases. Complaints duly received and cases initiated by the administration, shall be docketed and raffled for investigation and hearing. Section 150. Venue. Any complaint against a licensed recruitment agency, arising out of a recruitment violation, or violation of the conditions of the license, or complaint against an overseas Filipino worker, or a principal or employer for disciplinary action, may be filed with the Adjudication Office, or with the POEA regional centers or extension units having jurisdiction over the place where the complainant was recruited or resides, at the option of the complainant. The office where the complaint was first filed shall take cognizance of the case. Section 151. Change of venue. A complaint filed before the Adjudication Office may be transferred to the POEA Regional Center or Extension Unit, before the respondent files the answer, upon motion or request of either party and on meritorious grounds, subject to the approval by the administration. Section 152. Referral to the POEA Regional Center or Extension Unit for reception of documentary evidence. The Adjudication Office may, upon request of the parties, refer to the POEA Regional Center or Extension Unit the reception of documentary evidence. The Regional Center or Extension Unit shall endorse the received evidence to the Adjudication Office for inclusion in the case record. Rule 5. Action upon complaint or report. Section 153. Issuance and service of show cause order or summons, and filing of answer. Upon receipt of the duly docketed complaint or report, the administration shall issue a show cause order or summons, directing the respondent to file a verified answer and not a motion to dismiss, within 10 calendar days from receipt, attaching proof that a copy was sent to the complainant. The show cause order or summons, including a copy of the complaint or report and its supporting documents, shall be served upon the respondent. Section 154. Failure to file answer. In case the respondent recruitment agency fails to file an answer, the assigned Overseas Employment Adjudicator or OEA shall proceed with the investigation or hearing of the case. An answer filed out of time shall not be admitted except on meritorious grounds and upon motion. In case the respondent principal or employer, or the overseas Filipino worker fails to file the required answer, the case shall be archived, and the respondent shall be temporarily disqualified from participating in the overseas employment program, until the respondent files an answer. Section 155. Motion for extension. Only one motion for extension of time to file answer shall be allowed. The OEA, upon receipt of such motion may, upon meritorious grounds, grant a non-extendable period of 10 calendar days. However, if the allegations in the complaint or report refer to facts or circumstances which occurred abroad, thereby making it necessary to verify with the concerned principal or employer, a longer period not exceeding 15 days may be granted. A ruling on the motion made by the OEA shall be entered into the minutes, or sent by personal service or by registered mail. Section 156. Proof and completeness of service. The contents of the return shall be proof of the facts stated therein. Service by registered mail or through courier is complete, upon receipt by the addressee or agent, but if the addressee fails to claim the mail from the postmaster, service shall take effect a day after the date of the last notice. Service made at the last known address shall be sufficient in case the office of the licensed recruitment agency is closed, and no notice of change of address or cessation of operation has been filed. Personal service made in any registered office or officer, or personnel of the licensed recruitment agency, shall likewise be sufficient. For this purpose, in case the office of the licensed recruitment agency is closed, and no notice of change of address or cessation of operation has been filed, service to the last known address shall be deemed completed. Section 157. Nature of proceedings. The proceedings shall comply with the requirements of due process, without strictly adhering to the technical rules of procedure and evidence, applicable to judicial proceedings. The OEA may avail himself of all reasonable means to ascertain the facts of the case. Section 158. Preliminary hearing. The OEA may conduct a preliminary hearing with due notice to the parties, for the purpose of A. The possibility of an amicable settlement. B. The simplification of the issues. C. The possibility of obtaining stipulations, or admissions of facts and of documents to avoid unnecessary proof. D. The names and number of witnesses to be presented. E. The propriety of rendering judgment on the pleadings, or summary judgment, or of dismissing the action should a valid ground exist. And F. Such other matters that may aid in the prompt disposition of the action. Section 159. Non-appearance of parties. The OEA shall schedule a maximum of 2 hearings. If the complainant fails to appear in all of the scheduled hearings despite notice, the complaint shall be dismissed without prejudice to the refiling of the complaint, within the prescriptive period. If the respondent fails to appear in all of the scheduled hearings despite notice, the complaint shall be resolved based on the evidence on record. Non-appearance of both parties in all scheduled hearings will result in outright dismissal of the complaint without prejudice. If the case is refiled and dismissed again due to non-appearance of the complainant, the dismissal shall already be with prejudice. Section 160. Clarificatory questions. At any stage of the proceedings, and before the case is submitted for resolution, the OEA may ask clarificatory questions to the parties or their witnesses, to further elicit relevant facts or information. The OEA may set a hearing where the parties shall be given an opportunity to be present, but without right to examine or cross-examine. If the parties so desire, they may submit questions to the OEA, who may ask the parties or witnesses concerned. Section 161. Service of order to appear, or to produce documents. The administration may issue an order, to appear or to produce documents specified in the order. The process server who personally served the order to appear or produce documents, notice of order, resolution or decision, shall submit his or her return within 5 calendar days from the date of his or her service thereof, stating legibly in the return his or her name, the mode of service, the name of the other person to whom it was served, and the date of receipt. If no service was effected, the serving officer shall state the reason. The return shall form part of the records of the case. Section 162. Failure or refusal to obey order to appear or to produce documents. The failure of the officers, or employers of the licensed recruitment agency, to comply with an order to appear or to produce documents without justifiable reason, shall be deemed a waiver of their right to present evidence, and the case shall be decided in accordance with available evidence, and without prejudice to the filing of a case for noncompliance. Section 163. Summary judgment. Should the OEA find, motu proprio or upon motion, that a resolution or decision may be rendered on the basis of the complaint, answer and evidence submitted, the case shall be deemed submitted, and a summary judgment shall be issued. Section 164. Effects of withdrawal of complaint or desistance. The withdrawal of complaint or desistance shall not bar the administration from proceeding with the investigation of the recruitment violation. The administration shall resolve the case on the merits, if there is evidence warranting the imposition of appropriate penalties. Section 165. Resolution of the case. The OEA shall submit his or her findings and recommendations, in the form of a draft order, within 6 months from the date of filing of the complaint. The administrator shall render a decision within 2 months from receipt of the findings and recommendations. Section 166. Contents of order or resolution. The order or resolution issued by the administration, shall be clear and concise, and shall include the following. A. Facts of the case. B. Issue or issues involved. C. Applicable laws or rules. D. Conclusions and reasons therefor. And E. The specific sanction, remedy or relief granted. Section 167. Issuance of order of preventive suspension. Pending investigation of the recruitment violation or a disciplinary action case, the license of the respondent recruitment agency, or the accreditation of the principal or employer, or the processing of documents of the overseas Filipino worker, may be suspended, for a period not exceeding the imposable penalties under the Schedule of Penalties. Section 168. Grounds for the issuance of order of preventive suspension. 1. For the recruitment agency. A. There exist reasonable grounds to believe, that the continued operation of the licensed recruitment agency will lead to further violation or exploitation of workers being recruited, or will adversely affect friendly relations with any country, or will prejudice national interest. And b. The evidence of guilt is strong that there is a case for violation of the pertinent provisions of the Labor Code, its implementing rules and regulations, and POEA rules and regulations pertaining to serious or less serious offenses as described in these rules or any issuance of the administration. 2. For a foreign principal or employer. A. When the evidence of guilt is strong. And b. There is reasonable ground to believe that the continued deployment to the principal will result in further violation or exploitation of overseas Filipino workers. 3. For a migrant worker. A. When the evidence of guilt is strong. And b. The charge involves a serious offense. Section 169. Imposition of preventive suspension. A. After submission of the answer in accordance with Section 153, or after the lapse of the period within which to file an answer, and after the conduct of a hearing, the administrator may issue an order of preventive suspension in accordance with Section 168. B. The administration may, upon docketing of a recruitment violation case, and without prior notice and hearing, issue an order of preventive suspension, when the worker is a minor at the time of deployment. C. The administration may likewise issue an order of preventive suspension, upon recommendation of the Embassy or Polo, or when recommended by any government agencies, who are members of the Interagency Council Against Trafficking or IACAT, or the Presidential Task Force Against Illegal Recruitment or PTF-AIR, supported by a detailed report, sworn statement or statements of worker or workers, and other evidence. Provided that, the concerned party shall be given a period of 5 days from receipt of the show cause order, within which to file an answer or explanation. Failure to file such answer or explanation within the prescribed period, may result in the imposition of order of preventive suspension on the agency concerned. No motion for extension to file an answer or explanation, shall be allowed. On the other hand, the administration may, upon docketing of the case against a principal or employer, issue an order of preventive suspension in the following instances. A. When there are 5 or more complainants, and the nature of the offense involves serious or less serious offense. B. When the worker involved is an underage migrant worker. C. When the worker dies or suffers severe physical, or psychological maltreatment, or sexual abuse in the course of the employment. Or D. When recommended by the Embassy or Polo, supported by a detailed report and sworn statement or statements of workers. In case of a foreign placement agency, an order of preventive suspension shall be issued, on the basis of direct or indirect participation in the above-mentioned circumstances. The administrator shall render a decision, within 90 days from the date of receipt of the order of preventive suspension. Otherwise, the suspension shall be deemed lifted, without prejudice to the outcome of the investigation. Section 170. Effects of orders of preventive suspension and suspension or cancellation of license. An order of preventive suspension, suspension or cancellation of license, shall have the effect of suspending or terminating all activities of the recruitment agency which fall under the definition of recruitment and placement, including the processing of pending contracts of applicant workers. The suspension or cancellation shall not, however, affect the transfer of accreditation of the principal or employer to another licensed recruitment agency. Section 171. Imposition of fines. In lieu of the penalty of suspension of license of the recruitment agency, the administration may impose the penalty of fine which shall be computed at 50,000 pesos for every month of suspension. Section 172. Mitigating, aggravating or alternative circumstances. In the determination of the penalties to be imposed against a licensed recruitment agency, the following mitigating, aggravating and alternative circumstances attendant to the commission of the offense shall be considered. A. First offender. B. Admission of guilt and voluntary restitution, where applicable. C. Good faith. D. Exemplary performance. E. Habitual offender. F. Prejudice to the worker. G. Gross negligence, or H. Other analogous circumstances. The party must invoke in the complaint or answer or explanation, the existence of any of the above enumerated circumstances. However, when the imposable penalty is cancellation of license, the attendant circumstances shall not be applied. Section 173. Imposition of penalty. When applicable, the imposition of the penalty may be made in accordance with the following. A. The minimum of the penalty shall be imposed, where only mitigating and no aggravating circumstances are present. B. The medium of the penalty shall be imposed, where no mitigating and aggravating circumstances are present. C. The maximum of the penalty shall be imposed, where only aggravating and no mitigating circumstances are present. D. Where aggravating and mitigating circumstances are present, paragraph A, shall be applied where there are more mitigating circumstances present, paragraph B, shall be applied when the circumstances equally offset each other, and paragraph C, shall be applied where there are more aggravating circumstances. Section 174. Penalty when a case involves 5 or more workers. The penalty of cancellation of license, shall be imposed upon a respondent agency, found liable for committing a less serious or light offense against 5 or more workers in a single case. Section 175. Exempting circumstances. The following are considered as legitimate reasons for an overseas Filipino worker not to depart for the worksite, or to abandon or withdraw from employment. A. Exposure to hazardous or demeaning working and living conditions. B. Refusal of the principal to grant, release or remit wages and other benefits due the worker. C. War, plague or other calamities, or other dangerous situations at the worksite as determined by the POEA governing board. And D. Violation by the principal or employer of labor laws of the Philippines, the host country or international labor laws. Section 176. Motion for reconsideration. A motion for reconsideration shall be treated as an appeal. Rule 6. Disqualification of principal or employer, and overseas Filipino worker. Section 177. Failure to file the required answer. In accordance with Section 154, a respondent principal or employer or an overseas Filipino worker subject of a pending complaint for disciplinary action, who fails to submit to the jurisdiction of the POEA, shall be disqualified from participating in the overseas employment program until the respondent files an answer. Section 178. Automatic disqualification of principal or employer. The name of the principal or employer, shall be automatically included in the list of disqualified principal, or employer without further proceedings, in case a final and executory judgment issued by the NLRC against the principal or employer shall not have been satisfied. An order to this effect shall be issued by the administrator. For this purpose, any party shall furnish the administration, certified true copies of the order, stating the judgment award, and the sheriff's return indicating the failure of the principal or employer to fully satisfy the final and executory judgment against it. Section 179. Lifting of the automatic disqualification. The automatic disqualification referred to in the Proceedings section, shall be lifted upon full satisfaction of the judgment award, as evidenced by certified true copies of the sheriff's return, indicating full compliance or satisfaction of the judgment award by the principal or employer. Section 180. Temporary disqualification of principal or employer, and overseas Filipino worker. A principal or employer, who refuse to honor the medical result of a DOH-accredited medical clinic, shall be temporarily disqualified to participate in the overseas employment program. An overseas Filipino worker, against whom a warrant of arrest or a whole departure order was issued by a competent authority, shall be disqualified to participate in the overseas employment program, unless cleared by the administration. Section 181. Effect of disqualification of principal or employer. The principal or employer, against whom the penalty of disqualification had been imposed through an order, decision or resolution, shall be disqualified from participating in the overseas employment program, unless cleared by the administration, or the penalty imposed is lifted. An order of permanent disqualification, and delisting from the roster of accredited principals or employers, is immediately executory pending appeal. Section 182. Grant of clemency to a principal or employer. The administration may, upon motion by the principal or employer, grant clemency to a principal or employer who is penalized with the penalty of disqualification from participation in the overseas employment program, provided that the following conditions exist. A. The respondent is a first-time offender. B. The respondent did not commit a serious offense. C. The claims against respondent have been settled. D. The offended party has pardoned the respondent. And E. The principal or employer has the capacity to provide decent employment for overseas Filipino workers. The respondent may file a motion for clemency in lieu of an appeal. The filing of a motion for clemency shall be deemed a waiver of the right to appeal, or the automatic withdrawal of a pending appeal. Section 183. Grant of clemency to an overseas Filipino worker. The administration may, upon motion, grant clemency to an overseas Filipino worker who is penalized with the penalty of disqualification from participation in the overseas employment program, provided that any of the following conditions exists. A. The offense committed does not involve a serious offense, or crime involving moral turpitude, misrepresentation or theft. Or B. There is a settlement of claims, or the complainant has condoned the acts of respondent. Section 184. Grant of clemency to a partner, officer, or director, of a cancelled licensed recruitment agency. The administration, upon motion, may grant clemency to a partner, officer or a director of a recruitment agency, whose license has been cancelled, and whose name has been included in the list of persons with derogatory record, provided that the following conditions are met. A. The licensed recruitment agency has only one case, involving not more than 10 workers for which the license has been cancelled as certified by the adjudication office. B. The officer or director must prove that he or she did not participate in the commission of the charged violation. C. Proof of the full satisfaction of the awards on the case, if any. D. The complainant or complainants had condoned the acts of the licensed recruitment agency. E. The partner, officer, or director has not participated in the overseas employment program for at least 4 years from the time of cancellation of license. F. Submission of NBI clearance. And G. Proof of publication in a newspaper of general circulation, of the movant's intent to apply for readmission to the overseas employment program. The grant of clemency under this section may be availed of only once. Rule 7. Appeal. Section 185. Jurisdiction. The office of the Dole Secretary shall have exclusive jurisdiction to act on appeals from the orders of the administration. Section 186. Period 2 Appeal. The party aggrieved by a decision of the administration may appeal the same to the office of the Dole Secretary, within 15 calendar days from receipt of a copy of the decision. Failure of the aggrieved party to perfect the appeal within the reglementary period shall render the decision of the administration final and executory. The Docket and Enforcement Division shall not accept an appeal that is filed beyond the reglementary period of appeal. Section 187. Entry of Judgment. The administration shall issue an entry of judgment, upon failure to file an appeal within the reglementary period. Section 188. Requirements for appeal. The appealing party shall file a notice of appeal, and an appeal memorandum with the Docket and Enforcement Division of the administration. It shall clearly point out the errors of law and/or fact in the decision appealed from, and shall be verified. In case of fine and/or monetary award is imposed against the appealing party shall also file with the administration a supersedeas bond, in the amount of such fine and/or monetary award. The supersedeas bond shall be in cash, or in a surety bond acceptable to the administration, and shall be valid until the case is finally resolved. To be acceptable, the following documents shall be attached to the surety bond submitted. A. Certified copy of a valid certificate of accreditation and authority, issued by the Office of the Court Administrator of the Supreme Court, containing the photograph of the authorized agent. B. Copy of the Certificate of Compliance, with Circular Number 66 of the Insurance Commission, duly certified by the Insurance Commission. And C. Corporate Secretary's Certificate, containing the specimen signatures of the agents authorized to transact business with courts. In case any of the above requirements is not complied within the period provided above, the appeal shall not be given due course, and entry of judgment shall be issued by the administration, in accordance with the rules of court. Section 189. Transmittal of the records of the case on appeal. Within 5 days from receipt of the appeal seasonably filed with the corresponding requirements, the Docket and Enforcement Division of the administration shall transmit the entire records of the case to the Office of the Secretary. Section 190. Stay of execution. The order of the administration shall be stayed during the pendency of the appeal except A. When the penalty imposed is suspension of license for 12 months or more. B. When the penalty imposed is cancellation of license. Or C. When the penalty imposed is permanent disqualification against the principal or employer. Section 191. Period to resolve the appeal. An appeal from the order of the administration shall be resolved by the Office of the Secretary, within 60 calendar days from receipt of the transmittal of the entire records of the case. Rule 7. Execution of decisions. Section 192. Issuance of writ of execution. Unless otherwise provided in these rules, after the order has become final and executory, the administration, upon motion or on its own initiative, shall issue a writ of execution requiring the enforcement officer to enforce a monetary award and/or fine imposed in the decision. Section 193. Issuance, form and contents of a writ of execution. The writ of execution must be issued in the name of the Republic of the Philippines, requiring the enforcement officer to execute the orders of the administrator, or the Office of the Secretary or his or her duly authorized representative, as the case may be. The writ of execution must contain the dispositive portion of the order, or decision sought to be executed. It must require the enforcement officer to serve the writ upon the losing party or upon any other person required by law to obey the same, before proceeding to satisfy the judgment. Execution shall proceed against the assets of the losing recruitment agency in the following order. A. Supersedeas bond. B. Escrow deposit. C. Personal property. And D. Real property. A writ of execution shall not be necessary for the enforcement of orders in the following cases. A. For the return of travel and other related documents. A copy of the order served upon the losing party, or upon any other person required by law to obey such order is sufficient. And B. Where the agency had earlier posted a cash bond in relation to an appeal. Certified copies of the final and executory order and official receipt of the cash bond, shall be sufficient basis for the preparation of the voucher, for the release of the amount to be refunded, or for the confiscation, or forfeiture of the amount equivalent to the fine. The writ of execution shall be valid and effective, for a period of 60 calendar days from issuance thereof. Section 194. Motion to cancel or quash writ of execution. Within 5 days from receipt of a copy of writ of execution, the judgment debtor may file a motion to cancel, or quash the writ of execution on meritorious ground. The filing of such motion shall not stay the execution of the writ, unless a cash or surety bond is posted equivalent to the judgment award and/or fine, which shall answer for the same in the event that the motion is denied. An order denying a motion to quash the writ of execution is final, and no further motions of similar nature shall be entertained. Section 195. Enforcement of writs. In executing an order, the enforcement officer shall be guided strictly by the Manual of Instructions for Enforcement Officers of the POEA. Section 196. Garnishment. By virtue of the writ of execution, the enforcement officer shall issue a notice of garnishment to the person or entity having in possession or control of any property belonging to the licensed recruitment agency, directing said person or entity not to deliver, transfer or otherwise dispose of such property except to the above-mentioned enforcement officer. In cases where several writs of execution are issued against the same licensed recruitment agency, satisfaction of the claims of overseas Filipino workers against the escrow deposit shall be on a first come, first serve basis, irrespective of the date of filing of the case, or date of the decision, or date of the writ of execution, provided that where the orders of garnishment are served simultaneously, the escrow deposit shall be given prorated among the claimants. For fine imposed against a cancelled or delisted agency, its escrow deposit shall be subjected to garnishment. Section 197. Return of writ of execution. The enforcement officer implementing the writ of execution shall submit his or her return immediately upon the satisfaction of the judgment award. However, regardless of the outcome of implementation, the enforcement officer shall submit the return not later than 60 calendar days from date of issuance thereof. The return shall state the mode of service, the name of the person served, and the date of receipt. The return shall also indicate legibly the full name of the officer who served the writ. The return shall form part of the records of the case. Rule 8. Miscellaneous provisions. Section 198. Records of proceedings. The records of all proceedings before the OEA, which must be chronologically arranged and appropriately paginated, shall be summarized in writing by the OEA, including the substance of the evidence presented. The minutes of proceedings shall be signed by the parties, and shall form part of the records. In case the parties refuse to sign, the refusal and reason or reasons given must be indicated by the OEA in the minutes. Section 199. Appearances. a party may appear personally in his or her own behalf, or through a duly authorized representative. A lawyer appearing for a party, shall indicate in his or her pleadings and motions, attorney's roll number, PTR number, IBP number for the current year, valid mandatory continuing legal education compliance, and complete address. Appearances shall be made in writing with proof of authority to represent. The complete name and office address of counsel or representative of either party, shall be made part of the record, and the adverse party or his or her counsel or representative, shall be properly notified. Any change in the address of counsel or representative, shall likewise be put on record, with notice served upon the adverse party or counsel or representative. Any change or withdrawal of counsel or representative, shall be made in accordance with the rules of court. Section 200. Action on motions. Within the period required to file an answer, the OEA shall have the authority to rule on motions for extension of time to file pleadings, resetting and other similar motions, which may be done in writing or orally during the proceedings or conferences. Section 201. Consolidation of cases. Where there are two or more cases pending before different OEA, involving the same respondent or respondents and issues, the case which was filed last, may upon written motion and with notice to all parties, be consolidated with the first to avoid unnecessary cost or delay. Such cases shall be handled by the OEA to whom the first case was assigned or raffled. Section 202. Discovery of another offense. When in the course of investigation, another offense is discovered, the administration may issue the necessary supplemental show cause order or summons, or inform the respondent of the charge discovered during the investigation and enter the same in the minutes. The administration shall allow the respondent, the requisite period within which to file an answer to the supplemental show cause order or summons. Section 203. Discovery of another respondent. When in the course of the investigation, another licensed recruitment agency, principal or employer or overseas Filipino worker is found to have committed an offense related to the subject of the investigation, the OEA shall automatically implead said licensed recruitment agency, principal or employer or overseas Filipino worker in the pending case. For this purpose, a show cause order or summons shall be issued to the licensed recruitment agency, principal or employer or overseas Filipino worker in accordance with these rules. Section 204. Who may issue orders? The administrator shall issue orders of suspension of documentary processing, preventive suspension, cancellation or revocation of license, or dismissal of the case, lifting of penalties, and all other orders as may be necessary. Interlocutory orders may be signed by the Director Adjudication Office. Section 205. Prescription. All cases enumerated in these rules, shall be barred if not commenced or filed with the administration within 3 years after such cause of action accrued. Section 206. Applicability of the Rules of Court. The revised Rules of Court of the Philippines shall, whenever practicable, supplement these rules in similar or analogous character, in proceedings brought before the administration. Part 8. Assistance to overseas Filipino workers. Rule 1. Assistance to overseas Filipino workers. Section 207. Responsibility to overseas Filipino workers. The administration shall ensure that overseas Filipino workers are amply protected, and that their interests, well-being and welfare are promoted. Licensed recruitment agencies shall be responsible for the faithful compliance by their principals or employers of all obligations under the employment contract. Section 208. Request for assistance. The administration may take cognizance of any request for assistance, from the overseas Filipino worker or his or her family, on matters relating to overseas employment, or may refer them to the proper government agencies or the licensed recruitment agencies concerned, for appropriate action. Section 209. Monitoring of deployed workers, and submission of reports. The licensed recruitment agency shall monitor the status or condition of its deployed overseas Filipino workers, and submit a corresponding quarterly report to the administration. It shall likewise immediately act on complaints or problems brought to its attention, and submit corresponding reports to the administration. In case of significant incidents regarding the status and condition of overseas Filipino workers, the licensed recruitment agency shall submit a report regarding the same to the Welfare and Employment Office of the Administration, within 5 working days from the occurrence of the incident. After 30 days from the effectivity of these rules, the licensed recruitment agencies that deployed at least 100 domestic workers, shall employ at least one welfare officer or counselor in its office, to monitor and resolve domestic worker problems, or complaints at the job site. Section 210. Reporting of erring employer or principal. The licensed recruitment agency shall report to the administration any information that comes to the knowledge of the agency, with respect to any violation of these rules by their principal or employer. The matter shall be referred to the Adjudication Office or LRO for appropriate action. Section 211. Administrative sanctions. Failure by licensed recruitment agencies, and/or principals or employers, to submit reports, or to act on requests for assistance and/or complaints of overseas Filipino workers and/or their families, shall warrant imposition by the administration of such sanctions as it may deem appropriate. Section 212. Welfare programs and activities. The administration shall support and coordinate with other institutions, on projects and activities, that will enhance the welfare, and promote the interest of overseas Filipino workers and their families, including those that will facilitate the psychosocial and economic reintegration of overseas Filipino workers, who have decided to return home permanently. Rule 2. Repatriation. Section 213. Primary responsibility to repatriate overseas Filipino workers. Notwithstanding the provisions on compulsory insurance coverage as required by law, the repatriation of an overseas Filipino worker or his or her remains, and the transport of his or her personal effects, shall be the primary responsibility of the principal or employer, and licensed recruitment agency that recruited and/or deployed him. This entails the obligation to cover repatriation and attendant costs, including airfare and immigration fines or penalties. This obligation shall be without prior determination of the cause of the need to repatriate the overseas Filipino worker. After the overseas Filipino worker has returned to the country, the principal or employer or licensed recruitment agency may, however, recover the cost of repatriation from the overseas Filipino worker, if the termination of the employment was due solely to the overseas Filipino worker's fault. Section 214. Repatriation procedures. A. In case a request for repatriation is filed by an overseas Filipino worker at POEA, the labor attaché and/or welfare officer shall evaluate the request. Should there be a need for the immediate repatriation of the overseas Filipino worker, the labor attaché shall notify the principal or employer about the request for repatriation. If the principal or employer fails or refuses to provide for the ticket or costs thereof, the labor attaché shall notify the OA, and the POEA simultaneously of such need to repatriate. In case the request is received or filed at the POEA shall immediately notify the principal or employer, the licensed recruitment agency, and the POEA, of such request. B. The POEA shall immediately issue a notice requiring the licensed recruitment agency to provide, within 48 hours from such notice, the plane ticket or the prepaid ticket advice or PTA to the POEA or Philippine Embassy. The licensed recruitment agency shall notify the POEA of such compliance, which shall then inform OA of the action of the licensed recruitment agency. If the licensed recruitment agency fails to provide the ticket, or PTA within 48 hours from receipt of the notice, the administration shall suspend the documentary processing of the licensed recruitment agency, or impose such other sanctions as it may deem necessary. C. In case the repatriation of the overseas Filipino worker is dependent upon the issuance of an exit visa or clearance, the principal or employer shall have 15 days from notice to secure such exit visa. The licensed recruitment agency which recruited and/or deployed said worker shall exert earnest efforts in coordinating with the principal or employer to ensure the issuance of said visa. D. When the repatriation is dependent upon the issuance of an exit visa, and the principal or employer fails to secure the exit visa, within a period of 15 days from receipt of the POEA notice, the administration shall suspend the principal or employer from participating in the overseas employment program. In the same manner, where the licensed recruitment agency, despite issuing the PTA for the repatriation of the overseas Filipino worker, does not exert earnest efforts in coordinating with the principal or employer to ensure the issuance of said visa, the administration shall suspend the documentary processing of the licensed recruitment agency. E. Upon request, the administrator may issue an order lifting the suspension of documentary processing, only upon compliance with the directive for which the order of suspension of documentary processing was issued. F. When those primarily responsible for the repatriation fail to fulfill their obligations, the administration shall notify OA, to advance the costs of repatriation, with right of reimbursement against the licensed recruitment agency or principal or employer. The OA shall notify the POEA of the arrival of the repatriated overseas Filipino worker. It shall likewise notify the agency, that has the obligation to repatriate the overseas Filipino worker, and demand payment, within 15 days from notice, of the cost it has advanced for the repatriation of the overseas Filipino worker, including legal interest in case of default. In case the licensed recruitment agency fails to reimburse the OA, the latter may recommend to the POEA, the imposition of suspension of documentary processing. The POEA will direct the licensed recruitment agency, to settle its obligation with the OA, within 10 days from notice. Non-compliance with the directive of the POEA, shall result in the suspension of documentary processing. The suspension of documentary processing, imposed against the licensed recruitment agency and the principal or employer, shall be lifted by the administration only upon clearance by the OA. Section 215. Prohibition against performance bonds and deposits. The licensed recruitment agency shall not require any bond or cash deposit from the overseas Filipino worker to guarantee performance under the contract, or for the overseas Filipino worker's repatriation. Section 216. Emergency repatriation. The OA, in coordination with DFA, and in appropriate situations, with international agencies, shall undertake the repatriation of overseas Filipino workers in cases of war, epidemic, disasters or calamities, natural or man-made, and other similar events, without prejudice to reimbursement by the responsible principal or employer or licensed recruitment agency, within 60 days from notice. In such cases, the POEA shall simultaneously identify and give notice to the licensed recruitment agencies concerned, copy furnish the corresponding insurance companies. Section 217. Mandatory repatriation of underage overseas Filipino worker. Upon discovery, or upon being informed of the presence of an overseas Filipino worker, whose actual age falls below the minimum age requirement for overseas deployment, the responsible officers in the Foreign Service shall, without delay, repatriate the said overseas Filipino worker, and advise the DFA through the fastest means of communication available of such discovery and other relevant information. Rule 3. War risk areas and insurance. Section 218. Declaration of War Risk Areas. In order to protect overseas Filipino workers from the hazards of war or deteriorating political and security situations, the POEA Governing Board shall, pursuant to prior declaration by the DFA, declare specific areas as war risk areas. Section 219. Mandatory war risk insurance for overseas Filipino workers. In addition to the compulsory insurance coverage as required in these rules, all overseas Filipino workers bound for areas declared as war risk areas, shall be provided with war risk insurance coverage, in such amount as may be determined by the POEA Governing Board. This war risk insurance, shall be provided by the principal or employer at no cost to the overseas Filipino worker. Rule 4. Comprehensive and Integrated Public Education Program. Section 220. Public Education Program. The administration shall undertake a comprehensive and integrated public education program on overseas employment involving workers, licensed recruitment agencies, principals or employers and government personnel, for the purpose of promoting safe and legal migration and preventing illegal recruitment and trafficking in persons. Section 221. Workers' Education Program. The administration shall disseminate information, on labor and employment conditions and migration realities, to adequately prepare individuals, and empower them to make informed and intelligent decisions about overseas employment. Toward this end, the administration shall resort to modes of information and dissemination campaigns, such as the conduct of POS, in the form of community or mass-based POS, or POS online. Attendance to the POS shall be mandatory for all applicants for overseas employment. The POS shall cover all stages of employment, and may be country and skill specific. For domestic workers, the mandatory POS shall include their immediate family members. The administration shall likewise conduct a nationwide, multimedia campaign, to continuously disseminate anti-illegal recruitment laws and regulations, updated list of licensed agencies and entities, and other essential information through information and education materials such as brochures, pamphlets, posters, visual aids and other similar materials. Section 222. Partnerships with stakeholders. The administration shall maintain and strengthen its partnership with local government units, other government agencies, private sector, and civil society organizations advocating the rights and welfare of overseas Filipino workers, for the purpose of dissemination of information on all aspects of overseas employment, including the conduct of information and education campaigns on anti-illegal recruitment and anti-trafficking in persons. Section 223. Agency Education Program. The administration shall provide pre-licensing orientation seminars, and a continuing agency education program, for the officers and personnel of licensed recruitment agencies. For this purpose, the administration may charge reasonable fees to defray expenses to be incurred for such programs. Section 224. Orientation of principal or employers and overseas Filipino workers on-site. The administration, in coordination with the POLO or concerned entities, shall provide effective orientation to principals or employers, on the requirements, standards, laws and regulations in the recruitment and employment of Filipino workers. The POLO, in coordination with the principals or employers, shall conduct a POS for overseas Filipino workers. The orientation of principals or employers and the POS, may be conducted through an online system established by the POLO. The licensed recruitment agencies, shall undertake that their FPA shall effectively orient the employer and the worker on their rights, duties and responsibilities stipulated in the employment contract. Section 225. Training for POEA personnel. In order to be more effective resource persons and educators, the administration shall endeavor to update POEA personnel on developments on the local and global labor markets, and promote their participation in conferences and missions concerning migration issues. Rule 5. Registration of applicant workers. Section 226. Applicants Workers Registry. The administration shall adopt a system of registration of applicants workers, and maintain a registry of qualified applicants in accordance with the requirements of their occupations. Section 227. Manpower sourcing from the registry. Aside from the in-house placement facility of the administration, licensed recruitment agencies may source their manpower requirements from the applicants workers registry. Section 228. Referral of qualified applicants. The administration may refer qualified applicants from the registry to licensed recruitment agencies for possible placement. Section 229. Agency Manpower Pool. A licensed recruitment agency may maintain its own manpower pool for its prospective or accredited principal or employer, provided no fee shall be charged to the applicant, nor shall services be required in consideration of registration in the agency's manpower pool. Rule 6. Labor Market Research and Standards Development. Section 230. Research Studies. The administration, in coordination with relevant entities, shall establish a labor market information system, and conduct periodic and responsive research studies on the following. A. Labor market demand and supply. B. Prevailing labor market trends and conditions. C. Employment standards. D. Prevailing salary rates in the host countries. E. Immigration and labor policies of host countries. And F. Country and skill-specific employment contracts. Section 231. Bilateral or regional, or multilateral agreements. The administration, in coordination with relevant entities, shall pursue the conclusion of bilateral or regional or multilateral agreements, on labor cooperation with host countries. Rule 7. Code of Discipline for Overseas Filipino Workers. Section 232. Obligations of Overseas Filipino Workers. It is the duty of all overseas Filipino workers, to conduct themselves in the most professional, responsible and ethical manner in the performance of their duties, and fulfill the following obligations. A. Family. 1. Provide the family ample financial and moral support. 2. Communicate regularly. And 3. Preserve the integrity of the family. B. Fellow workers. 1. Assist, support, and cooperate with fellow workers. And 2. Refrain from committing acts which are detrimental to the interest of fellow workers. C. Country. 1. Obey the laws of the Republic of the Philippines at all times. 2. Abide by this rules and regulations. And 3. Be an ambassador of goodwill of the country. D. Licensed recruitment agency, and principal or employer. 1. Provide the licensed recruitment agency and principal or employer, with accurate statements or certifications regarding his or her skill, experience and other qualifications. 2. Understand and abide with the terms and conditions of the employment contract, as well as the company rules and regulations. 3. Maintain a high level of professionalism, and productivity in the performance of contractual obligations. And 4. Refrain from committing acts which are detrimental to the interest of the licensed recruitment agency or principal or employer, during the documentary processing and employment. E. Host country. 1. Respect the customs, traditions, and religious practices of the host country. And 2. Obey the laws of the host country. Part 9. Incentives and awards. Rule 1. Agency awards. Section 233. Three-tiered award system for licensed recruitment agencies. The administration shall confer awards to licensed recruitment agencies, in recognition of their consistent excellent performance in providing decent and remunerative employment to overseas Filipino workers, maintaining professionalism and upholding ethical recruitment practices. The licensed recruitment agencies qualified for the awards, shall be evaluated based on the following criteria. A. Compliance with recruitment rules and regulations, refers to the absence of record of adverse decision, preventive suspension, documentary suspension, and pending recruitment violation cases, and cases before the DOLE and NLRC. B. Technical capability, refers to the agency's management and recruitment capability, in terms of qualification of personnel, office facilities, or work environment, an ISO-certified quality management system, and an automated system of recruitment and deployment, including monitoring of workers on-site. It also covers the existence of a human resource development plan for agency personnel, as well as compliance with general labor standards and occupational safety and health standards, provision of in-house POS, and other similar education programs, to prepare workers for overseas employment. C. Industry leadership, for award of excellence or presidential award, refers to the agency's pioneering achievement in the entry to new or emerging markets, which is entirely new country and new market, no placement fees charged for workers deployed, expansion of market opportunities for overseas Filipino workers, membership in industry associations or positions of leadership in industry associations, and participation in the development and formulation of policies on overseas employment. D. Marketing capability, for top performer candidates, refers to the agency's accomplishment in the generation of new principals or employers. E. Deployment, refers to the volume and quality of deployment of a licensed recruitment agency during the period under review, terms and conditions of employment beyond minimum standards, ensuring good employers, and dealing with direct employers. F. Welfare programs and corporate social responsibility, refers to the provision of responsive welfare and allied services for the overseas Filipino workers, their dependents or families, exemplary acts of assistance in times of hazardous, dangerous or distressed situations, corporate social responsibility through socioeconomic and civic programs and projects, in coordination with government or with private entities or organizations, contribution to continuous manpower training and development, and skills upgrading of overseas Filipino workers. The three-tiered award system consists of the following categories. A. Top Performer Award. The first level award, which is given to a licensed recruitment agency that has been actively operating for at least 4 years, and has passed the criteria and threshold for the said award, which shall be conferred once every 2 years. B. Award of Excellence. The second level of award given to a licensed recruitment agency, which has received the Top Performer Award for 3 times, which shall be conferred once every 2 years. C. Presidential Award. The highest level of award given to a licensed recruitment agency, which has received the Award of Excellence for 3 times, which shall be conferred once every 6 years. Section 234. Incentives and System of Recognition. The recipients of outstanding agency awards shall be entitled to the following package of incentives. A. Presidential Awardees. 1. Extension of license validity for 3 full terms, effective upon expiration of license, subject to corresponding license fee and escrow agreement. 2. exemption in the submission of requirements, for the following applications or requests upon notice. A. Renewal of license, subject to corresponding license fee and escrow agreement. B. Establishment of branch office and additional office. C. Transfer of business address. And D. Letter of acknowledgement to principals or employers' representatives. 3. Approval of the following applications or requests upon notice, subject to post-submission and evaluation of documentary requirements. A. Renewal of registration or accreditation of principals or employers. B. Additional job order except for domestic worker. C. Upgrading of registration or accreditation. D. Revalidation of job order. And E. Change of officers or personnel. Except for item number 1, all agencies previously conferred with Presidential Award of Excellence, shall continue to enjoy the above incentives and privileges. B. Awardees of Excellence. 1. Extension of license validity for 2 full terms, effective upon expiration of license, subject to corresponding license fee and adjustment of bonds. 2. Approval of the following applications or requests upon notice, subject to post-submission and evaluation of documentary requirements. A. Licensing concerns. 1. Renewal of license. 2. Establishment of branch office and additional office. 3. Transfer of business address. 4. Change of officers or personnel. 5. Letter of authority to principals or employers' representatives. B. Registration or accreditation concerns. 1. Renewal of registration or accreditation of principals or employers. 2. Additional job orders except for domestic workers. 3. Upgrading of registration or accreditation. 4. Revalidation of job order. Except for item number 1, the previous recipients of the Award of Excellence, shall continue to enjoy the above incentives and privileges. Further, the Presidential Awardees, and Awardees of Excellence, shall also enjoy the following incentives. 1. Exemption from Philippine Embassy or POEA authentication or verification of employment documents of principal or employer except for domestic workers. 2. Open job order system. 3. Waiver in the submission of requirements for Special Recruitment Authority and Jobs Fair Authority. And 4. Publication of list of awardees in the POEA website with link to their websites. C. Top performers. 1. Extension of license validity for 1 full term, effective upon expiration of license, subject to payment of corresponding license fees, adjustment of bonds and post-submission of evaluation of documentary requirements. And 2. Publication of list of awardees in the POEA website, with links to their websites. All other incentives shall be valid until a new set of awardees has been selected. Such incentives shall be revoked, in case of suspension or cancellation of license of an awardee. Section 235. Other incentives and system of recognition. The administration shall, other than those mentioned in the preceding paragraph, continue to recognize exemplary performance of licensed recruitment agencies, and develop an incentive scheme to reward those that practice ethical recruitment standards, including the development of a white list of agencies, and other similar schemes. It shall also continually review the award system and its incentives, for the purpose of enhancing the system, taking into consideration developments in migration policies and practices, and trends in the global labor market, and affording the participation of various stakeholders in the process. Rule 2. Employers' Awards. Section 236. Two-level award system for principals or employers. The administration shall confer every 4 years, a two-level award, to deserving principals or employers, who have been major providers of decent and quality employment to overseas Filipino workers, and who have significantly contributed to their development, as well as the protection and promotion of their well-being, as follows. A. Ministerial Award of Commendation. The award shall be conferred once every 2 years by the Secretary of Labor and Employment to principals or employers who, based on safe, fair and ethical recruitment, have continuously hired overseas Filipino workers during the past 4 years. B. Presidential Award of Distinction. The award shall be conferred once every 6 years by the President of the Philippines to principals or employers who, based on safe, fair and ethical recruitment, have continuously hired overseas Filipino workers during the past 4 years, and has been a ministerial awardee for 3 consecutive times. Section 237. Criteria for Ministerial Award. The following shall be the criteria for the Ministerial Award. 1. Demonstrated preference and active hiring of overseas Filipino workers within the last 4 years. 2. Provision of superior terms and conditions of work, that will enhance the productivity of overseas Filipino workers. 3. Compliance with Philippine laws, rules and regulations on the recruitment and employment of overseas Filipino workers. 4. Active participation and contribution to the welfare and benefit of overseas Filipino workers' families. 5. Observance of no placement fee policy. And 6. No derogatory record within the last 4 years. Section 238. Qualification for Presidential Award. A recipient of the Ministerial Award may qualify for Presidential Award on the basis of the following criteria. 1. Contribution to the continuous manpower training, and development and skills upgrading of overseas Filipino workers. 2. Implementation of corporate social responsibility programs. And 3. Extraordinary acts of assistance to overseas Filipino workers in times of hazardous, dangerous or distressed situations. Section 239. Incentives for the Ministerial Awardees. Ministerial awardees shall have the following incentives. 1. Exemption from POEA verification of employment documents. 2. Exemption from securing letters of acknowledgement for the conduct of interviews of applicants. 3. Open job orders. And 4. Extension of validity period of accreditation to 5 years. Such incentive shall be automatically revoked, in case of suspension or disqualification of the awardee. Section 240. Incentives for the Presidential Awardees. In addition to the incentives provided in immediately preceding section, Presidential awardees shall enjoy the following incentives. 1. Exemption from the maximum limit on multiple accreditation. And 2. Extension of validity period of accreditation to 6 years. Such incentive shall be automatically revoked, in case of suspension or disqualification of the awardee. Part 10. General and Miscellaneous Provisions. Section 241. Authority to administer oaths. The administrator, or any person authorized under existing laws, shall have the authority to administer oaths, and require the attendance of witnesses, or the production of any book, paper, correspondence, memoranda and other documents relevant or material to the case or inquiry. The administrator may authorize other POEA personnel to administer oaths. Section 242. Construction. These rules shall be liberally construed, to carry out the objectives of the Constitution, the Labor Code of the Philippines, as amended, and the laws pertaining to overseas employment, and to assist the parties in obtaining just, expeditious and inexpensive settlement of disputes. All doubts in the implementation or interpretation of these rules, shall be resolved in favor of labor. Section 243. Amendments. Governing Board resolutions amending any part of these rules, shall be deemed incorporated herein. Section 244. Separability Clause. The provisions of these rules and regulations, are declared to be separable, and if any provision or the application thereof is held invalid or unconstitutional, the validity of the other provisions shall not be affected. Section 245. Repealing Clause. All policies, issuances, rules and regulations inconsistent with these rules, are hereby repealed or modified accordingly. Section 246. Effectivity. These rules, shall take effect 15 days from publication in a newspaper of general circulation, and from filing with the Office of the National Administrative Registry of the University of the Philippines Law Center. Signed this 26th day of February in the year of our Lord 2016 at Manila, Philippines. By the Secretary of Labor and Employment, and Chairperson of the POEA Governing Board, Rosalinda Demopolis Baldas. POEA Administrator and Vice Chair of the Governing Board, Hans Leo J. Kokdak. And Board Members, Alexander E. Asuncion, Felix M. Oca, Estrelita S. Hizan, and Milagros Isabel A. Cristobal.